Mr. Besser, but he doesn't have his camera on. There he is. Good morning.
Can you hear me now?
We can see you and hear you. And so you start whenever you're prepared, Mr. Besser.
Thank you, Your Honors. May it please the court, Lawrence Besser and Derek Tyler on behalf of Luis Alberto Martinez. This is a direct appeal from a conviction of aggravated assault, attempted kidnapping with a firearm, resisting arrest without violence, and battery, wherein the sentence imposed was a total of 20 years incarceration. The facts of this case as set forth in the brief are very simple and direct. Mr. Martinez went to a World's Gym in Lehigh Acres, Florida. He went there with the intention of picking up a woman with whom he wished to have sex. The evidence was when he got there, the victim, Miss Barcos, who worked at a nearby hospital, was on one of the workout machines. According to the testimony of the witnesses and Miss Barcos, my client grabbed her by the arm, attempted to walk her out the front door of the gym, at which point she resisted him and started to scream. The people heard what was going on. My client released her and walked out the front door. He got on his bicycle. The police were called. They got to the scene. My client was arrested out in the parking lot. At the time he was arrested, when they searched him, they found a 9-inch cucumber strapped to his penis. That cucumber was subsequently admitted into evidence and basically forms the basis for the issue on appeal. My client testified when asked by the prosecutor why he had a 9-inch cucumber strapped to his penis. He basically told the prosecutor it would make his penis look better, bigger and larger, and it was there to impress women. When the prosecutor asked him that question and he gave that answer, apparently she wasn't satisfied with his explanation that he wanted to make his penis look larger, and that's why he had a 9-inch cucumber duct taped to his penis, because then, without any factual support whatsoever in the record, she made the comment to him on cross-examination, well, you could also use that 9-inch cucumber to shove up Miss Barco's vagina. A totally inflammatory statement, not supported by any evidence in this case whatsoever. The objection was immediately sustained, but apparently that wasn't enough for the prosecutor to have the objection to that irrelevant question. It should be noted, Mr. Martinez was not charged in this case with any crime of any sexual nature. He wasn't charged with an attempted sexual battery, anything of that nature. Having made that incredibly inflammatory and unsupported comment in cross-examination, she circled back to it on closing argument, again, where she advised the jury that at some point that Mr. Martinez was getting the cucumber ready for action, and he intended to use the cucumber to inflict bodily harm upon her. Now, Your Honors, I think we can all agree in this case that the conduct of my client was reprehensible. But I believe at this point of the proceedings, this case is not so much about the conduct of my client. We all know who and what my client is, and the court may find him a despicable human being, but it's not at this point about his behavior. It's about what he said. I would submit to the court, the issue for the court on this appeal is the prosecutor's behavior and what she did in this case. And I would submit, yes.
Mr. Besser, the case basically your client testified. He said this was all a big misunderstanding. It came down to whether the jury bought the prosecution side or the defense side. On the
Absolutely.
prosecution, right, on the prosecution side, they established that your client attempted to drag the victim out of the gym at gunpoint the whole time, ostensibly for the purpose of having sex with her against her will. So once you get to that point, does it really matter whether the sex against her will involved a cucumber or not? I mean, isn't that really pretty irrelevant at that point?
Absolutely not, Your Honor, because the nature of the remark itself was so irreparably damaging and so tainted the jury panel that any chance at all of this jury listening dispassionately to my client's testimony and whether they should believe him or not was impossible. Once that comment is made to this jury, with women on the jury, Your Honors, there's no way any woman sitting on this jury, after hearing the comment from the prosecutor, without any evidence that my client was going to shove a 9-inch cucumber up the victim's vagina, it's an irreparable damage. They were not going to listen to my client's testimony dispassionately and give his testimony the weight it may or may not have deserved. And that's the whole point, Your Honor.
Mr. Besser, was there a motion for mistrial on the case? Or a request for a curative instruction?
No, Your Honor. And with regard to that, ideally, what the public defender should have done was object. If the objection is sustained, move for a curative instruction. If he did not feel the curative instruction, he would move to strike the statement. If the statement was then stricken and he didn't think that that was enough, he would move for a curative instruction and then a motion for mistrial, a 4-step process. His attorney did not do so. However, Judge, our position is this court can review it as fundamental error, because even if he had done all of that, even if he had asked for the remark to be stricken and a curative instruction, that would have been insufficient, okay? The remark was of such a nature that you can't tell a jury the remark that was made, and I don't want to repeat the remark again, but you can't make that remark to a jury and then think that a curative instruction is going to cure it, Judge. When I was in law school in 1975, we had Justice John Paul Stevens come and speak to us at the law school, and he was speaking about appellate procedure, about how you preserve something, and he was talking about curative instructions. And he actually quoted a statement from Justice Jackson, in which Justice Jackson talked about the fiction of a curative instruction. And the example that Justice Stevens used in front of our law school was somewhat analogous to this situation. He said a curative instruction is like taking a hot iron poker from a fireplace, shoving it up somebody's butt and then pulling it out and telling them to forget that it was there, that you can't forget something like that. And that's what happened in this case.
Isn't the sort of the order of things is motion for mistrial, and then if that's denied, you request a curative instruction? How it goes.
Or you can do request for curative instruction, and then if it's denied, you ask for a mistrial. But in any event,
I think it goes the other direction. But given that, we must view this as this is unpreserved error, so it would have to be a fundamental error, correct?
I understand that, and I argue in my brief that it is fundamental error because of the peculiar prejudicial nature of the comment. Now, the state in their brief makes the argument that this was not such an inflammatory comment as to be considered fundamental error. I would ask the state, when they get up to give their argument, to elucidate to the court, if this statement is not of such an inflammatory nature to be considered fundamental error, what could possibly be such an inflammatory statement as to be considered fundamental error? You cannot make a more fundamentally inflammatory argument to a jury than what was made in this case. And again, not only was it unsupported by the evidence, it was made on cross-examination, and after the objection was sustained in cross-examination and the prosecutor was put on notice that this is an improper comment to make to the jury, she repeated it 2 more times in closing argument to the jury. So again, my client's conduct in this case may have been despicable, but there comes a point in time where on the appeal it's got to be not so much about what my client's conduct was, because we know who and what my client was, but it has to be about the prosecutor's conduct and whether this court will protect a defendant's right to a fundamentally fair trial, even if it's a despicable defendant. Because even the most despicable defendant in the world under our system of justice is entitled to a fundamentally fair trial. And getting back to Judge Rothstein-Yoakum's question, there is no way that a jury, this could not possibly be considered harmless error, because once you throw this poison into the equation, there is no woman and probably no man either who can actually sit on this jury and then listen to my client's testimony dispassionately. My client had a right to have his testimony before the jury. It's up to them whether they believe him or not believe him. But when you so poison the well against somebody that they are incapable of listening to his testimony dispassionately, then he hasn't received a fair trial. And again, Your Honor, there is no way this was a proper statement. There's no way that it was a comment on the evidence. And there's no way that it could possibly be a harmless error in this case. And if the state thinks that this was not such an inflammatory comment and that it was harmless error, again, I would challenge the state. Tell this court what could be more possibly inflammatory than the remark in this case. This remark was totally uncalled for. It was beneath the dignity of an assistant state attorney in the state of Florida. Again, the job of the state attorney is to seek justice, not to seek a conviction. And when you bring the trial down to a level where you are intentionally, and I say intentionally, trying to prejudice the jury because she did this after she was warned by the judge not to, at some point, this court has to take action. And if the court believes that the evidence against Mr. Martinez was so overwhelming of his guilt, then my response would be, give him a fair trial. Let him present his testimony without it being tainted. And if the evidence against him is so overwhelming, then I guess the state would have no problem convicting him again. Except at that point, if he's convicted again, at least he will know that he will be convicted and doing his jail time after a fair and impartial trial, which should not deny him his due process rights. Thank you.
You have about 6 minutes left.
I just have 5 minutes for rebuttal.
That's fine. Thank you, Mr. Besser. Mr. Scheller.
Good morning. May it please the court, William Schellhart, Office of the Attorney General, appearing on behalf of the state of Florida. One thing that I would like to point out, we've discussed it briefly already, is that because these errors, alleged errors, were not preserved, the lens that this court is looking through is fundamental error. And in this case, it's important to consider, when you're looking at fundamental error, what the evidence was that the state presented in this case. So if we're looking at the main charges that happened inside the gym, the aggravated assault with a firearm, the kidnapping, the battery, you had the testimony from the victim, you had testimony from 5 eyewitnesses who knew the victim, you had video surveillance that captured almost the entirety of the offenses therein, and then there was a 911 call where Ms. Barco described what had happened to her, including the firearm. So this is not something where one comment or multiple comments reached down and affected the validity of the verdict. There was a multitude of evidence here, and the jury properly considered all the evidence before it. One of the things that I would like to respond to is Mr. Besser's quoting of the prosecutor's initial question of Mr. Martinez on cross-examination. He stated today, as well as several times throughout his brief, in quotes, to shove a cucumber up Miss Barco's vagina, to shove a 9-inch cucumber up Miss Barco's vagina. And the question from the prosecutor was, it could also be used to shove it in someone's vagina, correct? An objection was made as to argumentative, and the court, exercising its discretion at that point in time, sustained that objection. The comments by the prosecutor were not improper in this case either. The cucumber was in evidence. The prosecutor, during closing arguments, has the opportunity to explain to the jury what conclusion that they can draw from the evidence. Although Mr. Martinez was not charged with a sexual offense, the statements that he made to Ms. Barco about wanting to have sex with her, more vulgarly, but wanting to have sex with her, about making his mouth wet, about giving him an erection, that's why the cucumber is relevant. And it came into evidence, and the prosecutor, during their closing examination, their role is to help the jury in analyzing and applying the evidence, including the attorney's suggestions as to what conclusions can be drawn from the evidence. As such, attorneys are given wide latitude during closing argument to review the evidence, draw reasonable inferences from the evidence, and advance all legitimate arguments. So the prosecutor's comments were not objectionable during closing argument, and still we're looking through the lens of fundamental error. If there are no further questions from this court, I would forego the rest of my time and rely on the arguments contained in my brief. Thank you.
If
Thank
I
you,
can
Mr.
be
Gillard.
very briefly in response, Your Honors. I can understand the state's argument that it was not preserved and has to be under a fundamental error standard. I can understand the state arguing that this may have been harmless error. I can understand all of that. But what I cannot understand, and I think is inexcusable, is the state trying to somehow justify the comments and argue that the comments were proper. Under no set of circumstances would these comments ever proper in any way, shape, or form. And for the state to try to justify to the comments to the court is simply, to me, not.
Mr. Besser.
Yeah. Okay.
If this had been a cucumber in the brown bag with a sandwich, I might see where you're going with this, but this is, what do you have to say about the fact that he had already used this in a somewhat sexual nature by having it strapped to his personal area? I mean, it's already inviting the jury that why would somebody have this? What would they be doing?
And he was asked, and he answered that he wanted to make his penis look larger, Judge, for better or for worse. We live in a culture.
Mr. Besser, let me correct you, because you keep using the word look, and just to make it clear, he testified specifically because I believed at that time that it could be used to enlarge as a way to enlarge my penis. It didn't just say look bigger, but actually enlarge it. And considering that it was strapped to him with duct tape, I believe.
Again, Your Honor, I think the clear implication of his testimony was that he wanted to make his penis appear to look larger. But in any event, there was no factual basis. So I can understand the argument that it has to be reviewed under fundamental fairness. I can understand the argument that it wasn't harmless. But when the state and the court talks about, well, your client had the right to testify in front of the jury, my response to that would be a defendant's right to testify in front of the jury is rendered meaningless and worthless if a prosecutor can so poison the jury's mind against that defendant by a statement or series of comments that they cannot fairly and dispassionately consider his testimony. And I believe
that's the very point I'm making, though. If this had been just some other object and they, fashioned that this was what they were going to do with it, maybe that could be looked at in a fundamental error context. But he had already shown a willingness to use this for whatever sexual purposes. And it was, the objection was sustained, but it doesn't take away the fact that there is still a cucumber in evidence and it was being used for sexual purposes.
Again, Judge, we can argue another day and we can discuss whether the cucumber itself was properly admitted into evidence or whether there should have been an objection at the time of it actually being admitted into evidence. But there's no evidence that he intended to use the cucumber as a vehicle or as an instrument against her. There's no evidence to support that. The cucumber was strapped to his penis. There's no testimony or no showing that he was going to take
Well, doesn't
the
that sort of
cucumber-
speak for itself? I mean, frankly.
No, Your Honor. No, he was trying to lead her out of there. He may have taken her somewhere, unstrapped it or whatever. There's just no evidence that he was going to use the cucumber to shove it up her vagina, as the prosecutor repeatedly said. There's no evidence that that's what he intended to do with it, Judge. You know, I can sit here and be flippant. I can say there's just as much evidence that if he wasn't successful picking up a woman at the gym, he was going to go home, slice up the cucumber and put it in a dinner salad for himself. There's no evidence of that either. Okay, but there was absolutely no evidence that he intended to use it. And again, this was intentional by the prosecutor. The objection was sustained. She circled back to it 2 more times in closing argument. And again, I don't know how you can possibly make a more inflammatory comment. Okay, and even if by some possible stretch of the imagination, the court thinks that maybe the cucumber could have been used in a sexual manner, even then, the nature of the comment by the prosecutor itself was just so inflammatory that there is no way any woman sitting on that jury could dispassionately listen to my client's testimony. And that's the key. Yes, they had witnesses against him. Yes, they had eyewitnesses. Yes, they had this. Yes, they had that. But a defendant has a right to testify, has a right to present his testimony to the jury, and beyond that, has a right to have that jury sit and weigh his testimony dispassionately. And when you take away the right of a defendant to have his testimony weighed dispassionately because you prejudice the jury, intentionally prejudice them with the most inflammatory type of conduct imaginable, then you've taken away his right to a fair trial under any standard, even under a fundamental basis standard. And again, if everybody thinks that the evidence against him was overwhelming, let him have a fair trial. If the jury hears his testimony at a new trial without the poison in there and they convict him again and he gets the same sentence, so be it. But even the worst defendant in the state of Florida is entitled to have not only his day in court, but his fair day in court, where he gets a full and fair hearing without a prosecutor, an agent of the state, intentionally sabotaging their proceedings. And so again, Your Honors, in my point of view, we all know who and what my client is. This appeal is more so as to what the prosecutor's conduct was, not my client's conduct. I know what my client's conduct was. Everyone here knows what my client's conduct was. Now we need to focus on the conduct of an official member of the Florida bar who intentionally poisons a trial against him to the point where he could not possibly have a fair trial in this case. And I think that's what needs to be addressed by this court, with all due respect.
Much, Mr. Besser. In order to leave our virtual courtroom, you should click the leave button that is on your Zoom screen,
Got it.
lower right-hand corner, and then you'll be sent off into the ether and I'll call the next case.
Thank you, Judge.
Thank you both.